Welcome back friends to the class 23. In the previous video we have discussed the whole concept of property identification, and this is a very important video in which we will discuss about the title search report of the property or the legal report of the property, right? So in the class 24th I will practically show you a sample valuation report and a legal report probably in class 25th, so that you can actually understand how this report is made and what is the details that are actually contained in those reports, right? So this is the class 23rd about the legal report of the property. Now what is the legal report? We also call it the title search report. Title search report, right? So what do we mean by the title search report or legal report of the property? So after identifying the property, that the property is actually located physically at site where for which the title documents are submitted to us. Now we want to see that in those title documents the name of the property owner is mentioned. There is no doubt about it. So we want to see that these title documents are genuine. These are original documents, and the property owner name mentioned in those title deeds is the one who has actual right and ownership claim over the property. He is the one or she is the one who has the actual right or ownership of the property. I will give you one example. For example, a property was owned by or purchased by Mr. A in 1999. It was purchased by Mr. A in 1999. Later on, he sold the property. He sold the property in 2003 to Mr. B. He sold the property to Mr. B. Then Mr. B in 2015 sold the property to Mr. C. Then after that, in 2022, Mr. C sold the property to Mr. D, right? And now it is 2025, right? We are sitting in the March month of 2025. In 2023, what happened? That Mr. D died. Mr. D died, and in his family there were five legal heirs. Suppose his wife Mrs. D, his son Mr. E, his daughter Miss F, right? Three legal heirs, right? Suppose there are three legal heirs. In 2025, Miss F comes to you for loan. And she says that she is the owner of the property. And bank should give her loan basis her ownership. And she presents all the chain documents. This is called the complete chain of the property, that how the title actually moved between the years, between different persons. From Mr. A, it went to Mr. B, then Mr. C, then Mr. D. In all these registries, in all these title deeds, for example, in the title deed of Mr. B, the seller name of Mr. A must have been mentioned. In Mr. C's title deed, the seller name of Mr. B must have been mentioned. And similarly, in Mr. D's title deed, the seller name Mr. C must have been mentioned. So the chain is getting complete. There is no blockage or no break in that chain. A to B, B to C, C to D, right? That is called the chain deed or chain of the property, title chain of the property. So Miss F comes to you for property mortgage. As a banker, when you accept, you are trying to accept the property, you have asked your lawyer to submit a legal report, to submit the title search report. The lawyer physically went to the sub registrar office or whatever the government department you have in your locality, The lawyer went there. He physically records these transactions. He physically checks the record of these transactions that they have actually happened in the sub registrar office. The record is properly updated in the sub registrar office. He verifies these records. He verifies that these properties this property is not mortgaged with any other person. Then he will verify whether Miss F is having the ownership to mortgage that property or not, whether Miss F is the actual owner of the property or not. So friends, there is no document to prove here that Miss F has the ownership of the property. There is no registered will of Mr. D. There is no title deed executed by Mr. D to Miss F. Then how will the bank know that Miss F is the sole owner of the property and she has the sole authority to mortgage the property? There is no way for the bank to know that. There is no document executed for that. There is no updation for the same in the government records. When the bank verified, they found that Mrs. D and Mr. E are also the legal heirs of Mr. D, who unfortunately died in 2023. So they also have equal claim over the property as well. So if the bank rely solely on Miss F's statement and mortgage the property and gives the loan, then in future Mrs. D and Mr. E can raise a dispute in the court against the bank and raise a dispute on the property that we were also the owner of the property. We were also having the share on the property by virtue of law, because our father, our husband has died, Mr. D has died. We have also the ownership of the property. So that the mortgage created by Miss F is invalid, and bank has not done the proper verification and proper search on the property's title, whether the title of Miss F is clean or not. So that is why the mortgage is invalid, and the court will rule in favor of them only, because the bank is negligent in clearing the title of the property. So that is why the legal report, the title chain report or the title search report is important for the bank, in which the empaneled lawyer verifies the chain, that the title is moving in proper chain without any blockage, without any hindrance here, and he physically search the chain movement in the government department's office. That is why it is called the title search report. The title, the ownership is searched in the government departments, government records physically by the lawyer, right? So the next question arises that this chain can be 100 or 200 years long. That chain can continue from since 1850. So how much old record should be vetted by the lawyer? There should be some limit, na? The lawyer should vet the record of last 10 years, 20 years, 30 years, 50 years, 70 years, 100 years. How much old record should be searched by the lawyer? So friends, in India, there is a limitation act. There is a law called Limitation Act, in which it is mentioned that if the title is clear, if you have the clear title chain of last 11-12 years, the bank say they check for 13 years. So if the title is clear for the last 13 years, you have the complete chain records of last 13 years, you are able to verify this chain in the government department office, and there is no such breakage or hindrance that you have found in that chain, then the property will be assumed to be totally clear out for any defect in the title by the court. So that 13 years is the benchmark which is taken in India for the chain search of the property, for the title clearance of the property. This is mentioned in the Limitation Act. So the banks do the search for 13 years in the government records. So the next question arises, which title documents will be taken by the bank as mortgage with them? Obviously, the bank will take the latest title deed with them, original title deed with them for mortgage. They will take all the title deeds that have been done in last 13 years chain with them as mortgage. So they will take the 2015 title deed as well with them as mortgage. But if they take only 2015 and 2022 chain only, and they are sitting in 2025, then they will have the chain record of 10 years only. They will have the chain record of 10 years only, and law states that you should have the chain record and title clearance of at least 13 years. So since before 2015 there is no title document executed after 2003, so the bank will also have to take the original title deed of 2003 as well, so the bank will take the custody of that original title deed of 2003, 2015, 2022 with them to create a valid mortgage in the eyes of law. I hope you have understood this. So the question arises, sir, what if that this title deed of 2003 is lost? We are not able to find this title deed is lost, then what will be the option? The bank will have only 10 years of title search. Will there be any dispute regarding this? There can be a dispute, but there are very lower chances of this dispute coming, since after 2003 and 2025 already 22 years have gone by. So no legal hire of Mr. B can raise a dispute after 22 years. Since 13 years they have not raised any dispute, so after 22 years they cannot raise any dispute. So we can say that the property can be accepted here. But one more thing that I need to mention, that if this title deed is lost, then one thing that bank usually do is file the FIR report, do a newspaper publication. Sorry, I have mentioned you incorrectly here. The bank will have problem because that Mr. B was having title since 2015, and only 10 years have gone by, so the legal heirs can raise dispute. Sorry, I have mentioned it incorrectly to you. So the bank will do FIR. Bank will ask the customer to do the FIR for losing this title deed, and he will ask the borrower or property owner to file a newspaper publication that this title deed bearing number this and this is lost by us, and if someone has any objection or any information regarding this or any dispute regarding this, then they have to submit us within 20 days, within 30 days, whatever the timeline is suggested by the lawyer. So there will be a cooling period or waiting period of 2-3 months after that. Then post, if there is no dispute or information came after that, then the bank can mortgage these properties by taking the original copy of FIR and the newspaper publication in their record, right? So the legal property should be legally clear, and the ownership is legally enforceable. The ownership is legal. In simple terms, there is no defect in the title of the owner of at least last 13 years as per the Limitation Act. And the legal title search report is done by the empaneled lawyer. I have already explained to you. Complete title chain of last 13 years, how the property moved from A to B, B to C, C to D has moved. He search all these records in the government departments. He takes all the original title deeds, verify the genuinity of the title deeds, and gives the clearance report to the bank. Verify the chain from the government records. Then he gives his legal opinion, which we call the legal report. I will show you legal report in the class 25th. And he will suggest what documents are required by the bank to create the valid mortgage on the property, undisputable mortgage on the property. He will also suggest the documents to be taken by the bank, like the title deed of 2022, 2015, 23, or if this is lost, then FIR copy or the newspaper publication copy. All of these suggestions will be given by him in his report, and bank has to comply with all of his suggestions. Then after that, after he has given his suggestions, when the bank receives the actual original documents as per his suggestions, then the lawyer will come in the bank premises, or the bank official will go to the lawyer premises with these original documents, and the lawyer will check the genuinity of these original documents and prepare a vetting report mentioning that which are original documents that are seen and verified by him in the presence of the bank official, and that vetting report is also kept as a part of loan docket as a final documentation by the bank in their records. So this is the final concept of the total legal report that is done by the bankers. I hope you have understood and enjoyed this video. Meet you in the next video. Thank you very much.